South Africa's corporate sweetheart MTN has its logo wrapped around the Springboks and is celebrated in business and political circles alike. But behind this public branding lie serious allegations. Open Secrets published its investigative report called #ShutdownsEverywhereYouGo, exposing MTN's role in internet shutdowns.
This investigative report revealed how MTN and its subsidiaries have been implicated in human rights violations through its work with foreign governments across Africa and the Middle East by facilitating internet shutdowns during war, civil unrest, and elections. They have also been accused of corruption, tax evasion, and enabling terror activities.
MTN is currently embroiled in a legal battle with communications company East Asian Consortium, or EAC. EAC alleges that MTN unlawfully displaced it from a telecommunications tender by bribing senior Iranian government officials. Open Secret's work on corporate accountability is part of a broader civil society push across the world to make sure that the rise of multinational corporations is not met with a rise in impunity. For this reason, Open Secrets has applied to be Amicus curiae, or friend of the court, in the case between EAC and MTN. A court date is yet to be set at the Constitutional Court of South Africa. EAC is a private company which in 2004, as part of the Turkcell Consortium, successfully bid for Iran's first private telecommunications license. The following year, the Iranian government altered the structure and terms of the telco license, and Turkcell was replaced by MTN as a major telecommunications service provider in Iran. EAC alleges that MTN acquired their telco license through bribery and corruption, causing $4.2 billion worth of financial losses. MTN denies these allegations and alleges that the change in the structure and terms of the telco license automatically invalidated EAC's successful tender. This case forms part of a 10-year protracted legal battle between EAC and MTN, with EAC seeking justice for their financial losses that they claim were caused by MTN's corrupt activity. EAC has brought its case before courts in Iran, the United States of America, and the Permanent Court of Arbitration in The Hague, but have not won any of these. In 2013, EAC launched legal proceedings in South Africa's Gauteng High Court against several MTN companies, including MTN Group Limited and MTN International, as well as 2 former directors who EAC claimed had a direct hand in the alleged bribery. Before the merits of the case were heard, MTN challenged whether the court even had the jurisdiction to hear the case to begin with. MTN argued that ruling on the matter brought by EAC would in effect require the court to evaluate and pass judgment over the actions of a foreign government, in this case being Iran. This is not generally permitted by South African or international law, which protects governments from such assessments for reasons of sovereign equality.
So what is this case really about? Put simply, should South African courts have the ability to judge the corrupt activity of South African corporations that implicate the conduct of foreign governments? EAC appealed the High Court's decision to the Supreme Court of Appeal. On appeal, the SCA ruled by a narrow majority that the case could proceed because the alleged corruption infringed upon rights protected by South Africa's constitution, which rights the courts are obliged to protect. The MTN respondents have now appealed that finding to the Constitutional Court, which will have the last word on whether or not South African courts have the authority to hear matters involving the executive actions of foreign states, where those actions involve bribery or corruption.
Open Secret's main reason for intervening in the case is simple. We believe strongly that South African courts must be able to regulate the activity of South African corporations acting elsewhere, even for corporate activity that implicates the actions of foreign governments and especially where corruption is alleged. While the case may be between corporations with competing interests, its outcome could have a transformative impact on how South African corporations can be held accountable. In our intervention, we highlight the emerging international law norm which recognizes corruption as a human rights violation and holds those implicated in corruption to account. In in turn, this invalidates the justification for not adjudicating the actions of a foreign state and allows such matters to be heard before South African courts.
A clause in an agreement concluded between MTN and its Iranian business partners on 18 September 2005 stated, "The cooperation between MTN and the Iranian shareholders should be in line of defensive, security, and political cooperation." This is precisely what is at stake in this case. Through our court intervention, Open Secrets hopes to make sure that MTN and companies like it, which are headquartered in South Africa, are held accountable for their transnational conduct before South African courts.
We believe this to be the responsibility of our courts in upholding international law, the Constitution, and protecting human rights.